Scott. Good afternoon, everyone. Hopefully I'm presenting now. I think I am. Okay. Enjoy your lunches. Make sure you wipe the crumbs off your fingers when you're typing in those poll questions. I want to thank everyone for joining us today, both our insureds and those who are coming to check out the services we have to offer. As Scott indicated, my name is Garrett Kern. I've been at the Mutual for almost 4 years now, and as part of my, service, I not only handle claims, handle risk management questions, but also present on various topics that we have identified, through our claim handling, through other resources as being things we think our insureds and lawyers in Illinois can benefit from. As Scott indicated, and as the emails have all said, and why you signed up today, we're going to talk about client screening, engagement, disengagement, and non-engagement. The reason why we're talking, what you'll see is a common theme through all of these, through to this afternoon's presentation, is about communication, clear communication with your clients, clear communication with those prospective clients that may not have become clients, and clear communication with those whose matters you are no longer representing them on for whatever reason. We have found through our claim handling process, through anecdotal evidence as well as empirical evidence, that clear communication, it not only negates claim activity, but is super, super helpful and super beneficial to you in the defense of a claim against you. The first part of the presentation will be on client screening. Client screening could be a 3-hour presentation if we wanted it to be, but we wanted to keep this to an hour and include the information on the engagement, disengagement, and non-engagement. If you have further inquiries about client screening, you can always go to our website. You can contact me directly, or you can call us at our risk management hotline, and we can certainly walk you through some of our thoughts and provide some additional insight. So that being said, I normally do this live, and usually it's interactive. So Kathleen and Scott are going to jump in here from time to time with your questions. They're going to probably take more of a aggregate approach, see what topic is trending, if you will, and we'll find a good spot to answer those questions as we go through. And as Scott said, I'll stick around at the end, and in the event I don't get to your question, we are tracking all of the questions, and we'll do our best to respond to them timely. So on client screening, let's start with a story. Everybody likes a good claim story. This one is taken from a variety of claims that actually happened. Names have been changed, locations, etc. But the reality of this is something that we see pretty regularly. In this scenario, we have Sally, who's a successful business person, who's embroiled, unfortunately, in some complex commercial litigation and needs some legal assistance. She sought out the representation or the assistance of an attorney, one of our policyholders that we'll call David. David had provided excellent service to a colleague of Sally's, and as many of you know, word of mouth is the best way to garner business as well as your reputation. And I'll pause a little bit and say I've seen questions about other materials. I believe we will be sending materials out. The slides will be submitted after the presentation. Great. So back on point, David, to his credit, is a very high qualified, highly successful litigator, handles lots of complex litigation matters. The one thing that David does not do very well is scrutinize his clients or their backgrounds or their stories or their cases. In this scenario, Sally came in as a promising client with a promising case, and David, without batting an eye, accepted the opportunity, but as noted, carried through with his sort of custom and practice of not doing a good deep dive or confirming or doing any due diligence into Sally's claims, her background, or her history. That would come back to haunt David as through the case, throughout the case, Sally's her testimony changed, the story of the case changed, her willingness to participate in the litigation went from significantly interested to almost non-existent. She failed to pay her bills. She failed to assist in answering discovery and things of that nature. And as the case progressed, David learned of certain other dealings that Sally had been involved with other companies and litigation involving her other companies, her experience with other attorneys, and things of that nature that may have, if David had learned of them in the beginning, deterred him from taking on the case. Many of the allegations that David could have discovered hindered his investigation, hindered his defense of the case, leaving himself vulnerable and his client vulnerable to attacks once the case moved forward to a point of really no return. Despite the mounting evidence, David remained on the case. He took the case to trial, and ultimately, as you can imagine, a negative outcome was found against Sally. Sally, having taken copious notes and arguably planning a malpractice claim from almost the outset, submitted a claim saying that he neglected the case, his input, his legal advice, professional services were negligent, and that he caused the negative outcome. One of the big things that she complained of, which I should have noted, is his lack of communication. And David not being big on regular reporting other than through bills, opened himself up to that type of claim. During the discovery phase of the legal malpractice case, many witnesses, former employees of David, former lawyers of his that worked with him, identified his lack of protocol for client screening. And ultimately, while we thought we had a very good defensible case, the case ultimately settled. And that's why he had insurance. But ultimately, the point of the story being a quality screening of this particular client, a deep dive, if you will, into her background, the background of her company. The result may have been different. He may never have taken on that client and therefore avoided a claim. So what do we learn from that example? And this slide indicates that we're going to talk a little bit about what things you should consider in a client evaluation. And I want to take this from the perspective of David, our policyholder, our litigator. Something that every lawyer should ask is, are you, the lawyer, competent to handle this matter? In this scenario, yes, he was competent. He had done these types of cases before. He had defended these types of businesses in the past. That was not an issue, but things that do come up from time to time that we have seen are requests from former clients to do work that's outside of your comfort zone, what we call dabbling in the industry. Audio is cutting out for somebody. And even if there are more people with audio cutting out, just let us know. The second question, and I have a scenario there as well, a case that I worked on that was not in the state of Illinois. We had a prominent plaintiff bodily injury attorney, did an excellent job